The US and UK legal systems share a common ancestor English common law. And think of it like two siblings who inherited their grandparents' antique furniture. They might use it differently, reupholster it, or even bicker over who got the better pieces. But the underlying structure, the craftsmanship, remains undeniably similar. Both systems rely on precedent. That means judges look back at past rulings to guide their decisions in current cases. It's like trying to bake a cake. You wouldn't chuck out the recipe every time, would you? You'd follow the instructions, adding your own flair along the way. But despite their shared heritage, the US and UK legal systems have evolved in distinct ways. The US, born from revolution, embraced a written constitution, enshrining individual rights and outlining the balance of power. The UK, steeped in tradition, relies on a patchwork of statutes, common law, and unwritten conventions. These differences, subtle yet significant, have shaped the legal landscapes of both nations, influencing everything from individual rights to the balance of power. It's a fascinating tale of two siblings, each forging their own path while carrying echoes of their shared past. The US Supreme Court, often called the highest court in the land, is a powerful force. It interprets the Constitution, settling disputes and shaping the very fabric of American society. Its landmark decisions echo through history, reflecting the nation's ongoing struggles with equality, justice, and individual rights. Brownville Board of Education, 1954, stands as a beacon against racial segregation. This landmark case declared separate schools for black and white students unconstitutional, dismantling the separate but equal doctrine that had fueled discrimination for decades. Roe v. Wade, 1973, though now overturned, ignited a firestorm of debate over abortion rights. The court ruled that women have a constitutional right to choose abortion, sparking ongoing discussions about privacy, bodily autonomy, and the role of government in personal decisions. Miranda v. Arizona, 1966, put the burden of protecting the accused on the shoulders of law enforcement. The ruling established the iconic Miranda rights, requiring police to inform suspects of their right to remain silent and to have an attorney present during questioning. This landmark decision safeguards against coerced confessions and ensures fair treatment for all, even those suspected of crimes. Obergefell v. Hodges, 2015, marked a momentous victory for LGBTQ+ rights. The Supreme Court ruled that same-sex couples have the fundamental right to marry, guaranteeing marriage equality nationwide and reflecting a growing national acceptance of LGBTQ+ individuals and their relationships. These landmark decisions, each etched into the fabric of American law, illustrate the Supreme Court's power to shape social change, protect individual liberties, and uphold the Constitution's promise of equal justice for all. Across the pond, the UK Supreme Court, established in 2009, plays a different but equally vital role. It stands as the highest court of appeal, ensuring justice and interpreting laws within the framework of the UK's unwritten constitution. Landmark rulings in the UK often reflect a delicate dance between upholding tradition and adapting to a changing world. Entick v. Carrington, 1765, stands as a cornerstone of privacy rights. The court ruled that government officials couldn't just barge into private homes without legal justification, establishing a crucial precedent that protects individuals from arbitrary government intrusion. Donoghue versus Stevenson, 1932, introduced the neighbour principle into the legal lexicon. This landmark case established the concept of negligence, holding that manufacturers owe a duty of care to consumers. Imagine finding a decomposed snail in your ginger beer. Not pleasant, right? This case paved the way for consumer protection laws, ensuring that manufacturers are held accountable for the safety of their products. R. v. Nanar, 1991, tackled a long-held legal anachronism, marital rape. The court ruled that a husband could indeed be guilty of raping his wife, dismantling the archaic notion that marriage implied ongoing consent. This decision marked a turning point in recognizing women's rights within marriage, challenging traditional power structures and promoting equality within intimate relationships. Miller v. Secretary of State for exiting the European Union, 2017, threw a wrench in the Brexit gears. The Supreme Court ruled that the government couldn't just bypass Parliament and trigger Article 50, the formal process for leaving the EU, without parliamentary approval. This landmark decision reinforced the principle of parliamentary sovereignty, ensuring that such a momentous decision couldn't be made unilaterally by the executive branch. These cases, each a landmark in British legal history, demonstrate how the UK Supreme Court balances upholding established legal principles with adapting to contemporary social values and political realities. Despite their differences, the US and UK legal systems share some fundamental similarities. Both place a high value on protecting individual rights, ensuring that governments don't run roughshod over the freedoms of their citizens. Imagine a journalist in either country facing government pressure to reveal their sources. Both legal systems offer protections, albeit through different mechanisms, to safeguard freedom of the press and whistleblowing. Judicial review, another common thread, empowers courts in both countries to review and potentially invalidate government actions deemed unlawful or unconstitutional. Think of it as a system of checks and balances, preventing any one branch of government from accumulating too much power. It's like having a referee on the pitch, ensuring everyone plays by the rules. Both legal systems also demonstrate a remarkable capacity for evolution, adapting to changing social norms and values. Landmark cases like Obergefell v. Hodges in the US and RVR in the UK reflect a growing recognition of LGBTQ+ rights and women's rights, respectively. It's proof that the law, while deeply rooted in tradition, is not static. It can bend and adapt to reflect society's evolving understanding of justice and equality. Section 5. Distinct approaches, constitutions, courts and lawmaking. Now, let's delve into some key differences. The US operates under a written constitution, a document considered the supreme law of the land. It outlines the structure of government, enumerates individual rights, and serves as the ultimate benchmark for legal disputes. The UK, in contrast, relies on an unwritten constitution, a patchwork of statutes, common law, and conventions that has evolved organically over centuries. This difference in constitutional framework spills over into judicial philosophy. US courts often engage in constitutional interpretation, weighing laws and government actions against the rights and principles enshrined in the Constitution. It's like having a blueprint for a building and ensuring that every new addition adheres to the original design. UK courts, while mindful of human rights conventions, primarily focus on statutory interpretation, determining the meaning and application of laws passed by Parliament. The role of Parliament versus Congress also differs significantly. The UK system emphasises parliamentary sovereignty, meaning that Parliament holds supreme lawmaking authority. Courts can interpret laws but can't strike down acts of Parliament. It's like a parent setting the house rules. The kids might try to reinterpret them, but ultimately the parents have the final say. In the US, the Supreme Court can strike down laws passed by Congress if it deems them unconstitutional, a power known as judicial review. This power ensures that even the legislature is bound by the Constitution, preventing tyranny of the majority and protecting individual rights. Section 6. The US system, strengths and challenges. The US legal system, with its written constitution and emphasis on individual rights, boasts several strengths. The Bill of Rights, comprising the first 10 amendments to the Constitution, explicitly protects fundamental freedoms like speech, religion, and assembly. This clear enumeration of rights provides a powerful tool for individuals challenging government overreach or infringement upon their liberties. The separation of powers, another key feature, divides governmental authority among the legislative, executive, and judicial branches. This system of checks and balances aims to prevent any one branch from accumulating too much power, safeguarding against tyranny and promoting accountability. However, the US system also faces criticisms. The appointment process for federal judges, including Supreme Court justices, has become increasingly politicized, raising concerns about ideological bias influencing judicial decisions. The high cost of litigation and the adversarial nature of the US legal system often create barriers to justice, particularly for marginalized communities and individuals with limited resources. Section 7. The UK system, balancing flexibility and clarity. The UK's unwritten constitution, while seemingly less formal, offers its own set of advantages. Its flexibility allows for adaptation to changing circumstances without the need for cumbersome constitutional amendments. Parliament can respond relatively quickly to evolving social norms or address unforeseen challenges through legislation. The emphasis on parliamentary sovereignty ensures a strong connection between the lawmaking body and the people it represents. Since Parliament holds ultimate lawmaking authority, citizens have a direct say in shaping the laws that govern them through the democratic process. However, the lack of a codified constitution can lead to ambiguity and potential inconsistencies in legal interpretation. Critics argue that the UK system relies too heavily on judicial deference to Parliament, potentially limiting the court's ability to effectively protect individual rights, particularly in the face of overreaching legislation. Section 8. Real-life impacts. How court decisions shape our world. Landmark court decisions in both the US and UK reverberate far beyond legal textbooks and courtrooms. They shape social norms, influence policy decisions, and impact the everyday lives of citizens. Consider Brown v. Board of Education in the US. This landmark ruling didn't just outlaw school segregation, it sparked a civil rights movement, challenging racial discrimination across all facets of American life. Roe v. Wade, though now overturned, ignited a fierce debate about abortion rights, shaping political discourse and influencing personal choices for decades. In the UK, RVR fundamentally shifted societal understanding of consent and marital relationships, paving the way for greater legal protection for women from domestic violence. These cases demonstrate that legal rulings don't exist in a vacuum. They have the power to spark social movements, challenge established norms, and redefine the relationship between the individual and the state. Section 9. The rule of law, a cornerstone of democracy and justice. Despite their differences, the US and UK legal systems share a fundamental commitment to the rule of law. This principle, enshrined in both systems, dictates that everyone, individuals, corporations, and even governments, are subject to the same set of laws and legal processes. It's like a game of chess. Everyone, regardless of their status, must play by the same rules. The rule of law ensures predictability, fairness, and accountability. It protects individual rights, safeguards against arbitrary government actions, and provides a framework for resolving disputes peacefully and justly. In a world often marked by uncertainty and conflict, the rule of law stands as a beacon of stability, a testament to the enduring power of reason, justice, and the pursuit of a more perfect union both in the US and the UK.